Hi, and welcome to the first episode of Columbia River Economic Development Council's 2021 Grow Clark County podcast series. I'm Marnie Farnes, Relationships and Strategy Manager with CREDC. Today, you'll hear from two guests, Mike Wallace, co-founder and CEO of Perfect Company, and Kurt Rylander of Rylander & Associates, where he practices patent law. If you're an innovator or an aspiring innovator, I'm so glad you're here because today we're focusing on patents. And Mike and Kurt are sharing a lot of great insights, rounded up from their years of experience in the world of patents. I'm really excited to get started, but before we do, I just want to say a big thanks to our sponsors for making this podcast series possible. Clark County's Perfect Company, Firestone Pacific Foods, and Tiger Stop. A big thank you for not only your sponsorship, but your partnership. And also a big thank you to our presenting sponsor, IQ Credit Union. Let's hear from Julie Ahrens from IQ to share a few words.
Hey, business owners, thank you so much for logging in and clicking in today. We're super excited that you're joining us. My name is Julie Ahrens, also known as IQ Julie, and I'm blessed to work for IQ Credit Union, your local nonprofit, non-bank financial institution in town. We've been around since 1940 helping business owners business dreams come true. So whether you're a startup business and you have this dream and you're not ready to take it to the next step, or maybe you've done this for a really long time and you're ready to get out of business, so maybe you need help with succession planning or retirement planning. Whatever stage you're at in your business dream and in your business journey, IQ Credit Union is ready to help you. We've got a large team of business loan officers, business bankers, business account specialists, and we would love to partner with you. So thank you so much for joining us. We're super proud to sponsor the CREDC live podcast series. Excited you joined us, and IQ Credit Union is super excited to be part of this important series, helping business owners' dreams come true. So next time you need a business loan, business account, or some other business service, we hope you'll consider IQ Credit Union. You'll be glad you did. Enjoy.
Hi, and welcome Clark County entrepreneurs and businesses to this exciting conversation that we are going to have today with our guests, Mike Wallace, co-founder and CEO of Perfect Company, and Kurt Rylander of Rylander & Associates. We are going to talk today about patents. To those of you who don't have an idea today, you might have one tomorrow or next year. So I think that this is a topic that is relevant to any person in business. So with that, hi, Mike. Hi, Kurt.
How are you doing?
Hi,
Good. Welcome. And thank you for joining me today. Really appreciate it. I know you're both super busy, so appreciate your willingness to give to our community this way and to other entrepreneurs and maybe someday entrepreneurs. So great. So jumping right in, Mike, I'm going to start with you. Share a little bit about yourself.
So yeah, I'm currently CEO of Perfect Company, which is in downtown Vancouver. Just because of the situation, there's a couple of us that come here and work every day in our, 8,000 square feet, and now we've gone virtual, like everyone else. Mm-hmm. But yeah, I've really been a lifelong inventor. My first patent was when I was in high school. We can talk about that, but this is a subject near and dear to my heart. I've spent a lot of my life learning what not to do with patents and what works and what doesn't. So happy to have this conversation.
I'm sure. Real quick, tell us a little bit about what Perfect Company
is
and does.
So Perfect Company started, the original genesis of Perfect Company actually was a toy inventing company called Pure Imagination. You can see a lot of the products that we did on the back wall over here. And then in 2013, we invented a connected scale originally for making cocktails with an app that you pour in real time called Perfect Drink. And that really launched Perfect Company, and we went on in the consumer business and created Perfect Bake and then Perfect Blend. We partnered with Vitamix, where their consumer software partner. They sell our scales in their live demonstrations of their blenders. We invented and licensed the new NutriBullet blender, and so that sort of whole thing we did. And then recently we've been very involved in taking this technology that we have and going into commercial kitchens. And so that's a whole nother endeavor. We can talk about that a little bit and how it impacts this, but that's what we do.
Yeah, well, I know I've had the privilege of touring Perfect Company
that's right.
and seeing some of what's happening, and it's pretty neat stuff. So, and of course, I've talked a lot with Miriam, and just exciting things happening for your business. So, congratulations, and we're super glad you're in Vancouver, Clark County.
Thank you. Love being here.
Good. Well, we're glad you do. Kurt.
And by the way, Kurt has been our patent attorney in Vancouver for quite some time. So Kurt and I have worked together for many, many years at this point. I just say that up front before Kurt talks.
Excellent. Thank you. Kurt, tell us about you and what you're all about.
Well, I'm a patent attorney, but let me first say that I handle a lot of patent attorneys, and my firm does as well. And I have patent attorneys who work for me who've handled even more patent attorneys and even more inventors than I have. Mike is one of the most amazing and productive inventors that this firm's ever handled. I have a law firm I started 20 years ago after I finished working in Washington, D.C. for a law firm that focuses on patents and business. And so we handle a lot of inventions and trademarks and copyrights for a lot of different companies. And we represented Mike probably 13 or 14 years by now. So I can just say that Clark County is an extremely thriving and productive world for inventing. A lot of people and a lot of businesses are inventing a lot of things.
Hey, that's exciting. I love to hear that. And just speaking on behalf of CREDC, we are thrilled that both of you are in this world of inventing and protecting the inventions. So exciting. Well, thank you both for sharing. So Kurt, I'm going to start with you, and I'm going to ask you to tell, I would imagine anybody who's thinking about patents knows what a patent is, but just in case, we get all kinds of people tuning into our podcasts and whatnot. And so would you just share a little bit about what is a patent and what are the types of patents?
Okay. A patent is physically a document issued by a government, and that document lists certain areas that you have invented that you can stop other people from making products in. The best example is you created a light bulb, and the government says, okay, here's the light bulb you've created. Here's how to make it. Here's how to use it. Here's exactly what you've said is your light bulb. So nobody else in this country, without your permission, can make this light bulb. Now, the government doesn't stop anybody from doing it. The government just says, here's this, you can take it to a court, and the court will tell them they have to stop. And so as a result of telling people to stop, usually they negotiate a license with you so that they have to pay money to you to make your product. So that's the basic idea of what a patent is. It's a document that says what you're allowed to tell other people they cannot make or do. The types of patents vary based on country, but in the United States, in most countries, it's limited to three. There's a utility patent. When you say utility patent, think of a light bulb, the light bulb. Before the light bulb was invented, it was a brand new thing. So the light bulb is a utility patent. A differently shaped light bulb, say a light bulb that looks like a swan. Well, the light bulb's already been invented. You can't get a utility patent on a light bulb shaped like a swan, but you might get what's known as a design patent, which is the ornamental look of something that's functional. And then finally, there's a very strange area of patent law that very few people know about called plant patents. And I don't mean plants like a plant where you're making iPhones. I mean roses. I mean tulips. And it's largely focused on the flower industry is where plant patents have a huge amount of say. But if you go to any nursery in Clark County, Shorty's or any of the others, and you go to their roses, their tulips, their marigolds, you will probably see, if you look closely enough, patent numbers, because all of those are varieties that people have bred and they have plant patents on.
I always learn something in doing these shows, so thank you.
Yeah, that's a first for me too, I gotta say.
Yeah, well, it doesn't surprise me. And so it's interesting too that, and I guess I did kind of know this, that if you have a patent, if you have a patent on something, then really it's kind of up to you to know what's happening out there. How do businesses usually find out if somebody else has come up with the same idea and running with it? Either of you.
I have an answer, but Mike probably even has a better answer.
Well,
I threw that question in, sorry.
There's this concept of patents that is obviousness. How obvious is it that somebody's violating what you do? And so, as you can imagine, there can be minutia in patents that's hidden underneath things, and so it's very hard to know if your patent's being violated or not. And so there's this gamut of obviousness versus not so obvious in patents that make that difficult, right? And so yeah, I mean, you need to be able to establish that and know without a doubt that somebody is doing something that you have the rights to. And that's the very first thing, and that can literally mean dissecting a product, or it may be obvious just from looking at it from the outside. I'll let Kurt answer now.
Usually it comes to me because people who are making money on their inventions, they're out there selling and competing, they tend to know who their competitors are. They tend to know when people are entering their area and competing against them. And then they will come to me and they will bring a copy, or if they can, they'll bring the competing product to me and they'll say, does this violate my patent? And then, there's some things are really easy to establish. Usually mechanical objects are pretty easy to just kind of look at the patent and look at the mechanical object and you can see. In Mike's world, it's quite difficult because sometimes what's being infringed is aspects that involve software. And of course, he can't give me a copy of their source code. I can only get the application usually from the App Store or something else. It just shows me how it works, but it doesn't tell me how the code actually is doing it. And people can do the same thing in software. Every programmer in the world has written a thing called the Hello World code, but you could probably write that particular algorithm in 3 lines or in 300 lines, depending on what you feel like doing. So you kind of have to get beneath the hood of the car sometimes to really figure out what's going on to determine whether something infringes. And sometimes you just have to go to court and you find out later it doesn't, and then you're like, well, we're going to dismiss our suit because it doesn't.
Yeah, I mean, the short answer to that is if you really are curious and you need to know, you have to spend money to find out.
Sure, not surprising.
Right? I mean, you have to take somebody to court and find out.
Yeah, for sure. Hey, I feel like this might tie in with the next question, or maybe not, depending on which way you want to go, Mike. But so with patents, tell us all about your experience with patents. Well, maybe not all about, but give us some highlights.
Oh man, that's
and I'll leave it up to you. What do you feel inspired to share?
Well, I first off, I grew up wanting to be an inventor pretty much my whole life. Kurt can attest to this. Rom Popeil and Pocket Fisherman are one of my all-time.
I love that.
Right? And
I had one. I had a Pocket Fisherman.
Exactly. Very nice man when you speak to him. And so from high school, like I said, I got my first patent. I've always kind of been driven this way. But as you see behind me, with the toys, obviously patents became very important to us because our sort of the way we worked in this business is we would invent technologies and then create toys that leverage those technologies. And so nobody else had our IP and our capability to make these toys. And that was really the way we operate. So patents are at the core of what we do. Being able to protect that core piece, those core technologies and the applications we come up with after that were absolutely critical. But then that's also what gave us the ability to go to toy companies and get licenses and to talk to other toy companies and tell them they can't do that, right? And so it was absolutely central to everything that we did then. And it's the same with Perfect. Once again, Perfect is founded on some really core technology. We have more now, but that's the way we have always functioned. And so for us, being able to build up a patent portfolio and understand what that is, and then there's this interesting thing to think about as which patents do you take worldwide and which patents, because that's a whole nother ballpark. So
So expensive.
it's so expensive. If, you know, and that's one of the most difficult things is what patent is valuable enough to go off and spend hundreds of thousands of dollars,
Sure.
which is what it cost to go and get that patent issued and maintained and defended worldwide is an entirely different proposition. And so one of the most difficult things to do in creating and managing a portfolio is understanding where to spend your money and when not to spend your money, quite frankly. And that it's one of those things that I think I've gotten better at it. You sort of learn over time, but it's critical. And then also I think understanding, there's two things I've also come across when you develop these patents. One is you can have patents that are really offensive, where they're grabbing territory that you don't want anybody else to have. And there's also this concept of defensive patents, where I'm going to file this just because I don't want somebody else suing me sometime in the future. And I just want to have protection there. And a lot of companies think this way, or they'll disclose the ideas. You know, there's a whole nother realm. I used to work with the automotive industry, and you come up with a patent, they would evaluate it, or a patentable idea, they would evaluate it and decide whether they file a patent or they do a defensive disclosure. So there are actually whole journals where these companies publish ideas that they have because they want them to go in the public domain so they can't be sued on them later.
Yes.
Right, which is fascinating area as well. But for us, mostly it's deciding what patents to file that add value to the company and allow us to advance our business interests. And then, we can have a whole nother conversation, or we can go off another tangent, which is really sort of what's a good strategy for doing that? And how do you want to think about doing that? That's a much deeper conversation. But, at a high level, that's the way we think about patents is as we do things, we're constantly looking and evaluating what innovations we have, what are the opportunities. And, the hard part is, a lot of people get an idea and they want to spend money to protect it, but you don't know if it's worth money yet.
Yes.
That's the challenge.
That's the tricky part.
And I see a lot of first time or young inventors going through this where you think you have I did it. Think you have an idea, you go off and spend a bunch of money and you may get a piece of paper, but is it really worth anything? Is that product actually worth something? So one of the things we try to do here that I've tried to do for years now is to really prove out the commercial viability of that concept or that technology before we spend a lot of money protecting it. And you have to be careful when you do that, but it's worked for us so far.
Yeah. So Kurt, Mike or Kurt, how might a business know if it's worth the investment or putting?
Well, Mike has more on this, but I'll just tell you this, from what I've seen, because I've seen a lot of people get patents and make no money. A lot.
Yeah.
Because people know primarily their invention more than they know the market. So the ones who make money on their patents know the market that they're interested in really, really well. They know the market really, really well, and they know how to get their product to that market. Those two things are critical. If you don't know those two things, you might get lucky and learn it fast enough, but usually those are the killers.
So
yeah.
So Kurt, speaking of which, how much can somebody somewhat expect to spend?
Well, I keep track of this, and it varies by firm, by the way. There's firms in California and Chicago and New York that would be 10 times what I have. But for the average for all patents is about $8,000 from filing through issuance. Maintenance after issuance is a different thing. But it varies. It varies because there's certain types of patents that are more time consuming than others. For example, simple mechanical patents don't cost a whole much. Design patents also don't cost a huge amount, but highly involved mechanical patents, like a combustion engine, that could be significantly more than 8,000. Software patents, area Mike's in, electrical circuit patents, patents involving computer technology are almost always more than $8,000. Biomedical or pharmaceutical patents could be over $100,000. We don't handle those ones, but it does vary on the subject area. But for our firm, we've experienced about $8,000 to $9,000 average for filing issuance.
So it's worth it to do your homework before you take that step. And so how might a business know if it's time to take that step? Do you help with that, or how do entrepreneurs figure this out?
Well, in the case of Mike, he's been through the process so many times. Anytime he thinks like he's got something that's an invention that is economically viable, he sends it to us to probably file a provisional patent application on. So if you've been through this before, you have an idea of what's patentable or what might be an invention that's economically viable, and so you get a provisional patent application in right away, and then you worry a year later whether you want to continue that.
I see.
Yeah. And there is actually another wrinkle to that too, which is really interesting, because a lot of times when you're in product development and you're figuring out what that product is, a lot of times when you start and what you think is valuable is not what is valuable when you're done.
Oh, interesting.
And so one of the challenges here, honestly, is figuring out what to file and when, because almost always at the beginning of a product cycle and at the end, your picture of what that is are completely different.
Oh yeah.
Sure.
And so that's one of the challenges is how to manage that risk profile and knowing what to file and when. We tend to wait as long as possible because it just doesn't become clear sometimes until you have that first initial engagement, get some feedback, get somebody using it before you can really figure out what those nuggets are.
That makes sense. Hey, Mike, how many times have you been down the patent road?
It's a lot.
What's a guess? Just guess.
Just with our firm, probably 30 plus.
Yeah, I think career-wise, I'm approaching. I don't know if I've hit 75 yet, but it's
wow.
There.
So you know a thing or two about going down this road.
I do. It's
so.
a bit of become a hobby or even an addiction for me for a while, but
I'm sure.
I do love patents. Let me just say, I do love patents. I think they're incredibly valuable.
And if you decide to go international, I think that there's a multiplier effect. One patent can bloom into like 30.
It's true. It's true.
Interesting. So Kurt, share with us give us a high level overview of the steps. I've got something that I want to seek a patent on. What do I need to, what are some of the steps?
The first thing is you have to have a disclosure, usually a write-up. You either have to make it and build it to bring it into the patent attorney so you can see it, or you have to write it up with drawings and explanations so that the patent attorney can determine whether this is something that might be patentable at all. If you have those, then you have some choices to make. One, do you want a patent search done? So you can determine if someone else has patented that already or if it's already out there. You don't
do that, Mike? Kurt, do you do that?
Our firm does, but we outsource to contractors who specialize in doing just that. You really don't want to have a patent attorney spending a lot of time searching.
Yeah, okay, that makes sense.
It's really expensive.
Okay,
so you don't have to have a patent search done. So it's a choice people make. Then the next choice is whether you want to file a provisional patent application, which basically gives you a priority date, a place in line at the patent office, but that's never going to issue as a patent. That just gives you a year, kind of a reservation, a year-long reservation to file a regular patent application. And then you have to make a decision of whether it's something you want to have an international patent application on. And sometimes these decisions happen faster than you want because timelines are really critical in patent law. If you've shown your invention to your buddies at the bar, you basically have a year from that date to get your patent application in. Otherwise, you lose the right to get a patent.
Okay. So they would just have to show that it's been 2 years ago since Marnie shared her amazing idea. And so we just went with it.
And you know, people can lie. People can not tell their patent attorney that they did that. And so you file a patent application and they may get a patent on it. But if you get into litigation against anybody that has a decent patent firm, they will find out. And then you will be in a world of hurt.
Yeah. Documenting that line of concept to implementation to going first presentation to the market is super, super critical.
Very
Having been through
Mhm.
patent litigation, I can tell you, and it also being one of the most expensive forms of litigation that you can, massively expensive. That having that stuff and being able to produce it is incredibly important.
How do you know if you're a good your idea is a good candidate for an international patent? What does that generally look like?
Know your market.
Okay.
Yeah, it's if you have a product that you think is going to be successful or that is showing some success, you have more time to file the international patents. I forget what it is exactly.
You have a year,
what is that, Kurt?
You have a year from your priority date.
Okay.
That's right. That's right. So you have a little bit of time, but you know, like on the perfect drink stuff, we definitely we knew we were going to sell it in Australia. We knew we were going to sell it in Europe. And so we made a decision pretty early on to file that key original patent in a lot of regions worldwide, just because we thought it was important. A, it added to the value of the company, but B, it allowed us to ship products into those countries and have some form of protection. Or if we were going to license those products later, it gave us a basis to do that as well.
So what can't be patented? Like what can and what can't? Is there anything
New types of potatoes.
that new types of potatoes can be?
New types of potato. For some reason, based on the Irish potato famine, the United States Congress decided that new types of potatoes cannot be patented.
Oh,
Because they don't want anyone to have a patent on a staple of the world's food supply.
I see.
So the standards for it's not really, the standard for getting a patent is it has to be something that's useful. It has to be something that's novel in that the exact same thing has never been done before. And it has to be something that's not obvious variation of things that have been done before. For example, maybe no one's ever had a TV that's pink with polka dots, but it's really kind of an obvious variation. There's things with pink polka dots all over the place, and there's TVs. It's obvious to anybody who would want to do it. Those are the three main standards.
Okay. So Mike, what have been your biggest sources of frustration over the years? And you don't have an hour.
I don't have an hour.
Don't mention me.
Yeah, we'll leave Kurt out of this, although he's probably in the middle of it. I mean, the biggest sore point for me was we went through a giant patent litigation that took about 3 years and an incredible amount of money and time and resource and stress. I'd never been through a litigation like that before, and I hope I never am again. But yeah, we had to sue somebody who was infringing our patent, and it became this thing that went on and very expensive for basically 3 years. Yeah. And the amount of incursion into your free time and just distraction and stress and being interviewed and, you know, writing up testimonials and researching all the data and putting it together and reassembling timelines. It's an incredible drain on resources and time, and not the things you want to be doing if you're running a business.
So I'm slipping another question. Is the appeals process similar to what we usually think of when we think of appealing? So you get your answer in court and
Well,
not what you want. Can you appeal it?
Yes. So the first of all, patent litigation is highly complex because there's different ways of approaching litigation. There's different avenues. You can challenge patents at the patent office. So you could actually have a trial going on at the patent office at the same time you're doing a trial in court, and you're going to appeal from that trial at the patent office at the same time you're going to appeal from the one in the court. So it can be very complex. But generally, if you win or lose in a federal district court case, you can appeal it to the federal circuit. There's several courts of appeals in the federal system, but there's one court of appeal that handles all patent appeals. So even though we're here in Washington, and federal appeals would normally go to the Ninth Circuit, the patent litigation appeals go to the federal circuit, which is based in DC.
Yeah, and one other frustration I will add is I do believe, and in fact it's true, that patents have been weakened here in the US over time by large corporations spending time and lobbying Congress. It's way harder and more expensive to protect your IP now and defend it than it was, say, 20 years ago.
Yes, it's a very expensive litigation. It's 10 times more expensive than almost any other litigation.
Wow. See, just learned something else. That's interesting. So, Kurt or Mike, how long is a patent in place? Once you secure a patent, how long does it protect your idea?
You know, Mike?
Isn't it 25 years? Am I wrong? I'm probably wrong.
You are wrong, but it was actually pretty close.
20? Is it 20 years?
It's 20.
What is it?
It used to be. It's 20. It's 20. It's changed over time. Prior to 1995, it used to be 14 years from the date the patent was issued. No, 17 years from the date the patent was issued. I was thinking about design patents. 17 years from the date the patent was issued. They changed it in 1995 to harmonize it with the with the international system. So right now it is 20 years from your priority date. So if it takes 5 years to get your patent issued, Mike, then you only got 15 years left of your life of the patent. So it's 20 years from the priority date.
Okay.
That's right. And by the way, something we haven't talked about is that patent pending can be incredibly powerful.
Oh yeah.
Right. This is something people don't know and don't think about a lot, but just having while a patent is pending for the first 18 months, I believe, it's not published to the outside world. So nobody knows the contents of your patent, exactly what it's covering. And so just having patent pending is an incredibly powerful tool for going to market, and because you can defend a lot of turf just with the patent pending.
That's interesting. And are the protections similar?
No, patent pending
No.
is basically a deterrence. People see that.
I see.
It's like seeing somebody, with
It's
a tank.
the power of
You
suggestion.
don't want to mess with someone with a tank, even if the tank might actually have no bullets. So patent, you can't sue somebody until a patent issues, but seeing it alerts people that they could have a problem.
Sure. That's what I would think. I've seen that before, and it's like, oh, so my immediate assumption would be that it's a protected thing and don't go there. So the power of suggestion. So what about revising a patent? I have a patent. Is there ever a time to revise it or to modify it, or?
So that's a good question, and it depends on what you think. Most people think of patent applications and patents as the same thing. They're actually not. The patent application is what the patent office examines, and once it issues, then that's your patent. Now, during the patent application process, you can revise or modify to a certain extent your patent application. You can change it a little bit. There's some guidelines about it, but yes, you can make changes to your patent application during the patent restitution process. Once it issues, you're very, very limited in what you can do to it to change it. But usually that's not how it comes about. What happens is you file a patent application, and in the patent application you have, say, 10 claims. The claims are what the patent office examines, and each claim says, I claim a light bulb that plugs into electrical source that emits light. Claim 2 would be the light bulb of claim 1 that emits orange light. Okay, so you have a series of claims, and the patent office may say, we will grant the first 5 claims, we will deny the remaining 6 through 10. And the inventor will say to me, well, okay, I want to get a patent, but really claims 6 through 10, especially claim 7, those are really key and very important to me. And I say, well, what you do is this. We cancel claims 6 through 10 so your patent issues. But we file, prior to your patent issuing, a continuation application asserting same claims 6 through 10. So you have another patent application pending, and we will argue it. We will modify those claims a little bit. We'll change them to try to get them issued. So you typically have, and maybe you'll get a second patent. That's the revision that typically happens. And any good patent attorney at all will advise a client who has a patent application of any value to have many, 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 many continuation applications going on in the patent office. And so it's generally like a waterfall of patents that are issuing for the clients.
So like Mike, you, Perfect Company, like you have your scales, right? And so, and the technology that runs them. So if you, so you've got it, and let's say a year or two later, you revise it or you change the product slightly to make it better. You know, you've got 2.0. And maybe Kurt, maybe I just missed that you actually addressed this, but would Mike then need to get a whole new patent?
Generally, he will probably have a patent application pending because my clients always have patent applications pending.
Okay.
And so if it's something that's within the scope of what's already been filed, you can just amend the claims in the patent application to cover the new aspect. If it's basically kind of a new invention to it, then you might file what's known as a continuation of part, where you file a continuation application and you add in new material. If it's wholly a new innovative area, even though it's in the same area, you might just file your own brand new standalone patent application to cover the new area. So it really depends how closely related it is to the prior innovation.
Sure. Have you ever had to do that, Mike?
Oh yeah, I've done it all. Any of those variations, I've done them all.
Yes, he has.
Yeah, it is, as you solve problems, especially if you have a product that's sort of products are living things, especially software products. And they're constantly evolving depending on who your customer is and what you're trying to accomplish with it. And so, yeah, we would constantly, there's the original Perfect Drink, which extended to Perfect Bake and things like that. But as we got into things like blending, we came up to whole new ways of measuring ingredients that we hadn't done before. And in the end, we ended up, needing to file on those things.
Yeah.
And there's a bunch of other things that we did too. But it's sort of the nature of it over time is you may have a core of an idea, but if you really want to protect something, having this portfolio concept is really the way to protect a base technology over time. One patent, it's so easy to shoot down a patent in court or with a really good patent attorney, and so there's having a portfolio of patents that protect your concept from different points of view, if it's a valuable concept, is really, really important. It also makes your company more valuable. But then also, I think understanding when you develop the patents, something that I've gotten maybe marginally better at over time is a lot of inventors, including me, will do big hand claps and celebrations when we get a big claim, like, oh, this is a big thing. And it is. It's really, but the big claims a lot of times are the easiest things to shoot down in patent court and to kill a patent. Whereas if you can come up with all the little implementation details to make this happen, those little details end up creating something that can be very hard to overcome by opposing counsel. And so it's really important to think of patents as not a one core thing, but all the details that make that product or that technology important and work are the things you really have to think about.
Okay, that makes sense.
He's absolutely right. The best inventors in the world have actually been through a full round of patent litigation. I mean, it's probably the most expensive college to go to, but your understanding of what's important in patents is dramatically changed once you've been through a full course of litigation.
Oh, I'm sure.
Yeah, I mean, in modern parlance, that would have been me going to a major university for at least 10 to 15 years is what that cost me.
Nothing like,
it's a really valuable education.
nothing like getting in the pool to learn to swim.
Tell me about it.
Yes.
Or getting, yeah, that's just how it always works. So Mike, tell us about if we've got an idea and we've got a pending patent, or maybe we've secured a patent. What about funding, raising funds for your business, your idea? How does that all work?
Great. And paying your attorney. Very good point. Very good point. Or attorneys if you're starting a new company. The trick there is it's great to be able, we did it a very specific way, which is we self-funded for the first 2 years and really proved viability in the marketplace before we went and raised money. I mean, the thing to remember is the less track record, if you have zero revenue, if you're starting out, you're going to give up a lot more of your company for a lot less money if you can convince somebody to give you that. So being able to potentially have a first customer, have orders on book, be able to demonstrate the viability of that product or that technology is really the single most important thing that you can do. And then having a business plan on, if you get this money, then what are you going to do? And can you make a believable case that you can go out and make money with it, right? But more than anything else, it's you need to have some idea of viability in the product in the marketplace.
Okay. Well, that all makes sense. I think it's pretty standard when you're, from what I gather, when you're raising funds. So
it can be. I mean, there's a lot of seed money. That's the first earliest round where investors will put money into very small companies of 2 people, even one person sometimes. And it's all about, and the thing to remember when you raise money is it's a fuse. It's like lighting a fuse. You have a certain amount of time that money's going to last.
Sure.
And you need to get to the point where you're either making enough money that you don't need any more money, or you show enough progress and results from that you can raise a larger round and go to the next stage. And that's one of the things a lot of people don't realize is it's really about understanding the money you have and that it has to get you to a certain stage. And that's that you have to understand this all the time. And you're always raising money. You're literally always talking to prospective inventors and other people, not inventors, but investors, because that's just part of it, right?
Stay ahead of the game.
Right.
Yeah. So, Kurt and Mike, what about, does a patent guarantee protection? Like if I have something, a patent on something, can I just sort of coast?
No. So the patent, as I said earlier, it's a document that says what you're allowed to stop other people from doing. The government's not going to go do that for you. You have to sue people in court. It takes 2 to 3 years to go through the litigation. It's massively expensive. So though you're helped by helping yourself.
So you have to decide if it's worth it too to go to court.
Yes, you absolutely have to know, and you really need to have very reliable people tell you what you're expected to be spending. And actually, my firm, believe it or not, as massively expensive as patent litigation is, my firm's almost the cheapest one out there that does it. Almost all patent firms in the Pacific Northwest, let alone the nation, probably charge almost 5 to 10 times what I do to do it, and I'm not cheap.
Right. Well, yeah.
No, and the thing to remember about patents is even if you win a patent suit, you could completely win a patent suit, and the judge is still going to award a license to the loser of the patent litigation, and they can continue. It's very, very hard to stop somebody outright from using your patent. And so that's the thing to really understand here is, and on almost, well, I've been in a few lawsuits, none of them have ever actually gone to court. Litigation, especially patent litigation, a lot of this is about bloodletting until there's enough pain that the parties sit down and figure something out, or until one, both parties have to be at that spot where they're willing to reach that compromise. And that's really what litigation is to a large degree for most people. But the more important thing here is it's very, very hard if you have a patent to absolutely stop someone else from using it.
Yes.
Okay.
There is a huge advantage to having gone through the system, through it at least once for a company, and that is it makes for better patents. I mean, you draft disclosures for your patents for your attorneys to file much differently if you've been through it. But two, all patent litigation is public. It's publicly available for any attorney to research online. And so when someone sends a letter to one of my clients that says, "Hey, I'm going to sue you," first thing I do is look up, has this company ever filed a patent infringement suit before? Because if they haven't, then they probably have no idea what it takes to go through the thing.
Mm-hmm.
So being able to search online for Perfect Company and see, oh yes, they have been through patent litigation.
Mike knows.
The inventor Mike Wallace has been through it a number of times. Makes people take cease and desist letters a little bit more seriously.
That makes sense.
It's true.
Were you going to say something, Mike? Or
No, that
okay.
was really it. I agree with him.
Yeah. So what's a patent troll?
According to some people, it doesn't exist at all. According to some people, it's just an advertising campaign by Apple and Google and Amazon. A patent troll in the modern parlance is somebody that buys up patents and has no intention of ever manufacturing or making what's covered by those patents, and they're only buying patents so they can sue other people. That's supposed to be, according to Amazon and Apple and Google, a bad thing. But for inventors, it's not necessarily a bad thing, because it's really hard to make money on your patent if you don't have the ability to manufacture it yourself. So the idea that there's a marketplace for your patents can actually not be a bad thing. So depending on who you talk to, patent trolls are an evil force in this world, or it's a non-existent thing that's more like a fairy.
Oh, interesting. I know I read about a little bit and I was like, oh, that's kind of interesting. So I suppose if you have quite a bit of money and you can just buy up patents, then you're saving kind of that patent for your own.
The way they use it in the trades, the term for it in the trades and in litigation is non-practicing entity. You know, non-practicing entity is somebody who has the patents, but they're not actually making anything. They're just own and see these fees.
Why would they want to do that?
We've been approached by companies that do this, that want to purchase our patents.
Oh, I see.
And they said they have they've looked at our patents, they've looked at the market and decided they can use those patents and go out and prosecute them and make a certain amount of money.
All right.
And the funny thing is, these same companies who talk about patent trolls, Apple, Google, Amazon, all these, they all license their patents. They have all sorts of patents that they don't ever plan on making the product for. So they license it if somebody is interested in licensing. So they're all non-practicing entities themselves.
Okay. So a patent is a product.
Yes, you can buy and sell patents. So it's a product in the sense you can buy and sell patents. But when you talk about products with patents, you're usually thinking of the product that's made by making the invention.
Gotcha. Getting my terminology figured out here. So what about an intellectual property audit?
What? An audit. Okay.
Yeah.
That's a thing inventors that attorneys have come up with. It's probably a good thing for a company to go through, but it's also something you can have do to make more legal fees. So Mike might say, I need an intellectual property audit of my company. And so, that will require me to find out everything that Mike is making and selling to see what kind of intellectual property is involved. Does he have things that need patents on them? Does he have things that need registered copyrights on? Does he have logos out there that he has not sought federal registration of his trademarks for? So it's something to determine how much and what type of intellectual property he has and how well is it protected.
Okay. So it sounds like it's not really like a common thing, but that it's makes good sense and it is a thing.
I could find very little reason why a company would want to pay for a full intellectual property audit because they usually know what's important to them.
Okay.
I mean, I could say, give me $10,000 and I'll spend, 2 days at your office and find out everything you have. But I don't know that it would reveal anything more than what he already knows he wants protected.
But that being said, for instance, back to the fundraising, if somebody's going to invest in you and they're a lead investor, they will typically do some kind of IP audit
That's a flip.
to validate that. I mean, so that's very common. If you're raising money and an investor is going to invest in you, they will do some kind of IP audit to determine the value and quality of your IP.
So the investor does the audit, or they require you to have the audit done?
No, the investor does. It's called due diligence.
Yeah, it's part of the due diligence, exactly. And also, if one company is buying another company, very common to do that type of audit as well, right? It's part of the purchase.
Yes, that type of intellectual property audit does happen whenever there's going to be a purchase, where the main reason you're purchasing a company is there.
Yeah, and so it's not uncommon, and we've done it some to have portfolio assessed and kind of audited as sort of an advanced preparation for a round of fundraising, right? So we can say, this is our audit portfolio, this is our portfolio, this is the valuation based on certain things that we think it's worth, this is how we're going to use it going forward, all of those sorts of things.
Very good. Well, we're getting close to our time that I promised you we wouldn't go over. So in just wrapping up, Kurt, I'll start with you, and then Mike, we'll wrap up with you. But what are the top few pointers that you have for entrepreneurs, like that they can actually, after listening to this, they can either think about or put in place or pursue, whatever? What are the top 3 things that you think are the most important thing for your average just starting out entrepreneur?
Okay. One is the biggest thing in the world for me is go to an IP attorney to get a non-disclosure agreement. People get the worst, I want to say crap, non-disclosure agreements that just are not effective, that don't protect them, and that are not helpful, and that in many cases they've blown the ability to get a patent because they used a bad non-disclosure agreement. So getting a proper non-disclosure agreement first. Second, budget. When you've got an invention, you really should make a budget to the best you can to determine how much money you want to spend for a patent versus how much you want to spend on marketing and manufacturing. Because usually if people do that well, they may decide not to get a patent. It just might not ultimately be worthwhile, or at least they'll have an idea. So doing all the upfront paperwork before you start spending the serious money makes the most sense.
Yeah, that makes good sense. Mike, what about you?
For somebody starting out that has an idea, I think being very realistic about what the patent is for, that it's a tool, and very often the realm of patent pending is an incredibly powerful thing to use if you're an entrepreneur starting out. You don't need issued patents. Spend that money very wisely and get into your business to figure out what's actually valuable and what you need to protect. I think that's key.
Good advice, good thoughts. So Mike and Kurt, thank you both for spending this hour and sharing your experience and your knowledge. I know it's worth a lot. So thank you so much. Thank you for letting me just not know, and we could dive into this together. And, I'm okay with that. This isn't my thing, but I know that it's an important topic for a lot of entrepreneurs. It can either be the thing that propels them forward or maybe saves them the kind of the frustration and heartache. So thank you both. Kurt Rylander and Associates, and Mike Wallace from Perfect Company. Thank you.
Thank you very much. Thank you very much indeed.
Thank you, Marnie.
I just learned a lot about patents, and I'm guessing you did too. Thanks for joining me today. Be sure and connect with CREDC on LinkedIn, Twitter, and Facebook for the latest on what's happening in Clark County. Hey, in May, Will Masia from the Last U.S. Bag Company and Elizabeth Dick from Tiger Stop will be joining me to talk about exporting and business and what small businesses should consider when contemplating taking their goods or service across the U.S. and beyond. Until then, take care.